like to start by addressing one of the criticisms the negative team made about books. The point I brought up about books wasn't that they are exactly the same as software. The point of books is that authors have ideas which are just as deserving of protection, the same kind of protection that patents provide for software themselves. If you're trying to make the case that people who invent software deserve protection of their ideas rather than their expression, then there is no reason at all why you should not have the same kinds of protection available to authors. It's basically symmetry. You cannot have, or you should not have, one industry given special protection over another industry. And that was the essential point here. Not that software and books are identical, that they are somehow equivalent, but that the people involved in those industries have ideas about plots, ideas about character development, all kinds of ideas which are just as valid and just as valuable and could be considered just as much property as a piece of software. So there is no confusion there. They may not be the same, but the ideas could potentially be treated just as valuably. But we recognise the fact that if you try to do that with books, if you try and protect books in that way, what you end up with is a quagmire. An author wouldn't be able to write a book without the possibility, the risk, of several dozen other authors claiming patent infringement if we allowed patents around plots or patents around character development. We have exactly the same situation occurring in software. You cannot write any reasonably sized piece of software without taking the risk that somewhere there's patent which you don't know about, but that will be able to take you to court and will be able to take reasonably large amounts of money off of you. Now, gratefully, this isn't very common in New Zealand. It isn't a huge problem in New Zealand. It is a relatively large problem in the US. And this is the same kind of problem that Android is facing, where an open source operating system has been developed and that vague threats have been made against the operating system, and now finally, after it has been completed and brought to market, now people are coming and selling it. So we can't, in principle, I think, even if the ideas themselves are valid, we have to give them equal treatment to books. Either you give the ability to patent plots, or you remove the ability to patent ideas in software. I'd like to move on to another topic around how software patents are actually used. Because it's all very well talking about things in the abstract, about how they are in principle good and how they in principle help innovation. But the fact is that patents have been used as a hammer, as a club. An example I've been very familiar with was a certain patent around XML. And I know I'm going to get a bit technical, but the purpose of XML was to create a standardized document format and a computer readable system that is standard so that any system can understand the format of it. Previous to this, we had formats that, if you say you had a word processing document in one format using one program and you wanted to use another program, well, you couldn't because the format was proprietary to that piece of software. What XML was trying to do was create a standard so that everyone can interoperate with each other. In the open source community, we generated lots of different schemas and lots of different formats using XML to explain things, or to store things like word processing documents, spreadsheets, geographical data, and so on. But one of the interesting one of the common formats was word processing. A program called AbiWord existed about 1988, and in 2002 a certain company came along and decided they were going to patent certain aspects of XML, certain uses of it. And what they did is they tried to use these certain aspects of a certain way of using XML in their specific formats. So what this meant was, on the surface, they would look like they were using XML and that everyone could use it. But the way they had patented it was that if some other company tried to actually create something, a competing word processor, for example, those companies would be infringing the patent. And of course, there's no kind of legal agreement where you have to ask for a reasonable amount for a license for a patent. In fact, basically, you could ask for as much as you want. And when you have this kind of patent, it basically, and people know about it, who in their right mind is going to put millions of dollars into a word competing product when they know that that patent and possibly others exist and will be able to destroy the value of your software? That's example one. I've also just come from, I was just reading in New Scientist about a new, this is not software actually, but this is a new chemical called graphene, which could be incredibly useful in the electronics industry. And it's interesting because the scientist who invented graphene has tried to get it patented. And he went to one of the large electronics companies and said, because he's already invented it, and he was basically wanting to negotiate, like Brett suggested, an agreement about using this wonderful new graphene. And you know what the company said? They said they're going to throw 100 patent lawyers at it. They're going to patent all around it, and they're going to put him into litigation until he's dead. That's the negotiation that large companies enter into. You hear a bit about Stacker. Stacker was a disk compression utility for Windows back in the day, before Microsoft created its own one, and rather flagrantly didn't agree to a patent. So I think it's rather naive to suggest that small inventors are on the same level and have the same ability to negotiate as the larger companies. Thank you.